Well, that didn't take long for Blake Lively to turn the judge's ruling into PR. And she's the one that's constantly saying Justin Baldoni's the one that's running to the press for everything. Right. I'm tracking this correctly. Well, I just got done streaming and we looked at the new motion by the court, and the court has dismissed the amended complaint by Justin Baldoni. I read a couple pages of it. It's 132 pages. I'm not reading 132 pages, but we talked about it and I said it's going to take her a hot second to get the PR up for this unless she had a heads up, which I imagine she didn't. And I said, watch her go to people. Remember, I said I think her new move is she goes to people, especially for things around Taylor Swift and all these we're still friends, we're working it out PR drops to confuse people, to muddy the waters, because people has traditionally been Taylor Swift friendly, and Taylor Swift has traditionally used with Tree Pain people for her exclusives. That's well known with Swifties and basically everyone, I assume, at this point. So I've always said that Blake turned to people for her exclusives to muddy the waters, particularly in regards to anything she puts out about Taylor Swift. But look at this. 9 minutes ago, guys, we just got off the live and I checked Google before we got off the live. 9 minutes ago, she's already run to people. That didn't take long. And I said in the live, I said it's going to take her a hot minute, but watch, it'll go to people. Welcome to anyone that's new to the channel. I forgot to welcome you. I got so excited to dive into this. My name is actually Brianna Eve, and my background's in branding and marketing. I have over 15 years experience with a particular interest in narrative control and SEO. A lot of people see it as like PR moves, but I'm really interested in the mechanics that are going on behind the scenes of your favorite pop culture news, favorite pop culture stories. And then I bring you a unique lens here. We look at from branding and marketing. So I had a feeling that they were going to use this as a PR opportunity. They did with Leslie Sloan and the journalist from the Daily Mail coming out and saying, no, she never told me there was SH or SA. I don't know what you guys are talking about. They ran to people. They've done it again. Justin Baldoni's $400 million countersuit against Blake Lively and Ryan Reynolds dismissed by the judge. That's not even what happened. That's not even what happened. The judge granted motions to dismiss Justin Baldoni's lawsuits against Blake Lively, Ryan Reynolds, their publicist, and the New York Times. And a major setback for Justin Baldoni, the It Ends With Us director stars countersuit against Blake Lively, Ryan Reynolds, and their publicist, as well as his lawsuit against the New York Times, have been tossed out by the judge. We had a good friend of mine, Leanne Newton, on. She was she wasn't on, but she was in the chat on the last live that I just got off. And she said this was pretty much to be expected, that it wasn't overly shocking to her. On Monday, June 9th, Judge Louis Lyman granted the motion to dismiss the $400 million lawsuit filed by Baldoni and the Wayfair parties against Lively and Reynolds, which alleged extortion and defamation, as well as a $250 million defamation suit against the Times. The judge noted, though, that Baldoni's legal team can still amend the... See? Okay, what have you guys learned here? Right? Headline. 80% of people only read the headline. So they mislead you with this headline because the lawsuit isn't actually dismissed. This is misinformation. It's media manipulation. It's SEO manipulation, and it's shady as shit. Come on, people, do better. And then we also look at how the remaining of people pretty much read only the first 100 words. Like you're really lucky to get people further down in the article. So they add after. Well, it's not like dismissed, JKing. They can amend it. So the judge noted, though, that Baldoni's legal team can amend the claims for breach of implied covenant and tortious interference with contract if they choose to, with a deadline of June 23rd. Now, I'm going to say I'm not a lawyer, and I'm not reading 123 pages. Someone else might read the 123 pages. I got farm chores to do today. I want to enjoy the sun. It is hot AF, and after a long-ass winter in Ontario, Canada, I want to enjoy the sun. So I'm not reading 123 pages. But they can amend claims for breach of implied covenant. We'll look at the form. We'll look at a couple pages of it, and tortious interference. This says this is Judge Lyman. The Wayfair parties have not alleged that Lively is responsible for any statements other than the statements in her CRD complaint, which are privileged. Judge Lyman wrote in the opinion and order filing viewed by people, the Wayfair, everyone can view it, people. We can all view it. The Wayfair parties have alleged that Reynolds and publicist Leslie Sloan made additional statements accusing Baldoni of misconduct, and that the Times made additional statements accusing the Wayfair parties of engaging in a smear campaign. But the Wayfair parties have not alleged that Reynolds, Sloan, or the Times would have seriously doubted these statements were true based on the information available to them, as is required for them to be liable for defamation under applicable law. And look, I'm not a lawyer, but I assume everything's privileged between Blake and Ryan. So I imagine even if Ryan was in on it, that you're not getting those text messages that prove it. But again, not a lawyer. The judge added the Wayfair party's additional claims also fail. Accordingly, the amended complaint must be dismissed in its entirety. Attorneys for Baldoni did not immediately respond to people's request for comment. The Times has long stood behind its coverage of Lively's complaint that was filed in December 2024 and led to her lawsuit against Baldoni. She has alleged SH and retaliation, which he denies, and her lawyers have previously called his subsequent countersuit vengeful and meritless. A spokesperson for the newspaper previously said our story was meticulously and responsibly reported. I don't know about that. Lively 37 recently agreed to drop two of her claims against Baldoni, an intentional and negligent infliction of emotional distress, and a move her legal team described as a routine part of the litigation process for streamlining and focusing their case. In March, Baldoni's attorney Brian Freeman spoke out after Lively filed a motion to dismiss their countersuit, saying the actress's attempt to dismiss herself from the self-concocted disaster she initiated. Words are hard today. It's Monday, guys. It's Monday, and they're already popping off. This stuff's already popping off, and it's a Monday. It's going to be a week, I think. All right, let's try it again. Dismiss herself from the self-concocted disaster she initiated is one of the most abhorrent examples of abusing our legal system. He adds, at the time, stringent rules are put into place to protect the innocent, allow individuals to rightfully defend themselves. Laws are not meant to be twisted and curated by privileged elites to fit their own personal agenda. Ugh, I knew she was going to run with this, and it's got to just be heartbreaking. You know, I'm just thinking in my head, we read all the amicus briefs, so I don't want to go over all of them, but there is one piece that I want to pull up for you guys because I think it's really relevant here. So where the judge had said her statements are privileged, interestingly enough, the last amicus brief by Sanctuary for Families actually talked about that a lot, and I had a feeling that something was coming, like they were bracing, or like not just something was coming or they were bracing, but they were really trying to push the judge and show the judge, like, look, judge, look, she can say whatever she wants to any publication. She can go on a smear campaign. She can defame. She can go to any publication she wants because it's privileged. It's protected by 47.1. And I talked about it in that video where I said, I feel as though that's also why the New York Times wanted, I think it was a stay of discovery. Again, not a lawyer, but you could just see the writing on the wall as it would come out because they're waiting for all of this to happen, including the amicus briefs. All right, so it says here, Miss Lively's statements about her workplace. This is the amicus brief from Sanctuary with Families, or Sanctuary for Families. Miss Lively's statements about her workplace experience of SH and the New York Times reporting of the same are precisely the kind of statements that the California and New York statutes protect as privileged. There's that word. Which I personally don't agree with a law. Yes, protect victims. Absolutely. And I think that was the original intention with this law. However, what I've continually heard, not just by the amicus briefs, but by some lawyers on YouTube, is basically there's casualties in this. Sure, there's some false allegations. It's just a consequence of law. There are some misuse of it. Kind of the energy of too bad, so sad. And that doesn't sit right with me. So they say that this is privileged. There's that word. Indeed, California's amendments were motivated by statements made to the press about a prominent figure, which is symmetrical to Miss Lively's statements that were communications about her experience of workplace harassment that were then published by the New York Times. So what they're talking about here is New York, just above, New York's amended anti-SLAPP statute also protects journalists who exercise their First Amendment rights when reporting on misconduct, SASH, Like Michael Balter, who was sued by Danielle Curran, an archaeologist at the University of California, Santa Barbara, after he did exactly that. In 2020, Mr. Balter had reported on Curran's abuse and retaliation of her students through several posts online. In a letter to the Honorable Vincent L. Brissetti, just 2 months after New York modified an anti-SLAPP law as described supra, Mr. Balter's counsel advised at the court that he intended to apply the statute to Mr. Balter's case. The amended language in New York, while designed to protect women, also protects journalists who seek to share those stories because they are matters of public interest, which was added to the law. Again, in response to the previous anti-SLAPP statute's language, the amendments aim to provide more protection and in turn promote more speech. And I don't necessarily disagree that we need to protect victims and make it feel safe to come out. I just don't agree with the fact that what we're saying is they can also go. There's another example this amicus brief has where they say they can go and hold a press conference. There was a woman that held a press conference, and when the person she was accusing of SH or SA tried to file a defamation lawsuit, it was shut down because she was allowed to hold a press conference and talk about it and destroy this person's life. And that's the problem I have with these. So I worked actually in the mental health field for a very long time. SA, SH were a lot of things that I dealt with in the day-to-day working with children, youth, and adults, especially when I was working with youth in group homes. It was something that was frequently dealt with. I agree there needs to be protection, but I just really struggle, as I feel a lot of Justin Baldoni supporters struggle with, the idea that someone that is positioning themselves as a victim or making allegations can say whatever they want, ruin someone's complete life. And sure, yeah, they eventually in court, maybe they get cleared, but what was the damage that was done in the meantime? And both amicus briefs talk about how it's 8 to 10% of allegations are false. And they say, well, it's probably a lot less than that because a lot of women drop it because of fear of judgment or fear of the litigation process or fear, like basically women are making legitimate accusations, but they're dropping it out of fear or the invasive discovery process. But I also want to propose something separate. Are there a lot of men, maybe even women, who have a lot to lose by that going public and they're extorted? And someone says, look, I won't go to the press with this if you pay me $5 million. I won't go to the press with this if you give me what I want. And therefore, it's looking at 8 to 10% of there's 8 to 10% of false allegations. Is there a possibility that there's more, yet people are settling cases because of fear of what it'll do to their reputation in life? But I think the problem becomes, in my mind, when we have these sweeping situations and we just say, well, sorry, guys, 8 to 10% of people, sorry, sucks to be you, basically. We're not having the nuanced questions that actually move things forward and actually give people the protection they need on, especially for potentially false allegations as well. Now, there's something else I wanted to talk to you guys about. This is a motion to compel. This was submitted on the 6th. So I think this was like Friday evening. And y'all, I'm not recording videos on a Friday evening. I love y'all. I love this community. But one thing I've learned over, the last year of really wanting to bring you guys breaking news in this case is also I need to protect my sanity. And always checking dockets and always being hyper aware of every little thing was just not good for the mental health. So this came through on June 6th, and this is compelling Wayfair to turn over any alleged communications with content creators. Now, I want to say this first. Again, not a lawyer, but I've seen a lot of people say, I haven't seen Justin Baldoni saying anything. They're not making public statements. That's kind of, I think, what Blake's team is going for here is, well, you're not saying anything, but you're going to content creators and giving them the things to say. You're leaking information or maybe even paying content creators to have a certain view and essentially smear Blake Lively. I do have a video with Kirsty Flaw. And with that, in that video, we talk about how she is mentioned in a lot of these subpoenas that potentially or allegedly she had been speaking with Wayfair and they got her to release the video, that little bump video. If you guys have seen the little bump video. And I asked her, And she says, "No." And she says, how would they even know that I had it to reach out to me?" So you can check out, I'll put that video in the notes here so you can check it out next if you haven't seen it yet, but it's a great video. And I ask her straight up. So what Blake's team says here is, "Dear Judge Lyman, on behalf of Blake Lively and Ryan Reynolds, we write pursuant to the rules 1C and 4C of your honor's individual practices to respectively request an order compelling Wayfair, Justin, Jamie, Steve. It ends with us, Melissa, Nathan, the agency, and Jennifer Abel to respond to certain interrogatories propounded by the Lively Reynolds parties. The interrogatories at issue seek basic information regarding the identity of potential witnesses and documents relevant to the litigation." So they received it 3 months ago. They said Wayfair has not provided any substantial request or response to the request. So they're basically asking, let's see here, respectfully submitted that this gamemanship must be put to an end and the Wayfair parties be ordered within 5 days of the court's ruling of the motion to provide responses to these. And so it was that original one that we had talked about in that video. Says the Wayfair parties should identify the email accounts provided to third parties. So they're talking about content creators, journalists, etc. As modified, the Lively Reynolds parties request each Wayfair party to identify any email account from May 1st, 2024 to date in which any third party, including but not limited to content creators or the media, had access for the purpose of communicating information of any kind, including messaging, talking points, guidelines, scripts, or other information regarding Miss Lively, Mr. Reynolds, the digital campaign, CRD complaint, or the actions. Example A at 6, as counsel explained on several occasions, the Lively Reynolds parties believed that the Wayfair parties have engaged in covert tactics to communicate with third parties in a manner to avoid leaving a paper trail, such as placing information in a draft folder or other email repository. That is wild. Does that really happen? And providing a third party with viewing access to the folder or email, which enables third parties to view the information without leaving a digital trace. The Wayfair parties have never denied that they've engaged in clandestine communications. Despite this, the Wayfair parties refuse to provide any response by disingenuously claiming that the content of access is vague and ambiguous. They say Wayfair parties are well aware of the purpose of this request, yet continue to plead ignorance about what the basic English word access means in an effort to justify withholding plainly relevant information. The Wayfair parties, part 2, the Wayfair parties should identify the reporters they have communicated with. I have never communicated with them. I'm going to say that I have been accused of it a lot. And I always joke that I wish I had Steve Sarowitz money because then I could buy a bigger property and help more animals at my farm animal sanctuary. So like, I wish I had Steve Sarowitz money or I was on payroll for Steve Sarowitz because I would believe what I'm saying anyway. So I just get paid for saying the truth of my beliefs. Each of the Wayfair parties have requested to identify all reporters and news or media outlets of any kind with whom you have communicated in any manner concerning Miss Lively, Mr. Reynolds, the CRD complaint, the actions, or the Lively Reynolds companies. To narrow the scope, the Lively Reynolds parties agreed to limit the date range from June 15th, 2024 to the present for all parties. The relevance of the information sought is not in dispute, particularly since Miss Lively alleges that in mid-June 2024, Mr. Baldoni took to the offensive in response to her complaints of this onset misconduct, putting the retaliatory smear campaign in motion, which to this day involves the pervasive use of friendly media sources to ferret their narrative into the public. If it's so covert, how would they know about it? Is it just from having access to Jennifer Abel's cloud? Like, did they see something in there? Because I think they had access to that through this year. And Jennifer Abel didn't realize. I don't know. In their latest response, Wayfair parties seek to narrow this request to 1, a discrete subset of topics, 2, a 6-month window, June 15th, 2024 to December 21st, 2024, and 3, individual reporters only where reasonably known or ascertainable. Example A at 5, each of these proposals is inappropriate. On the subset, they would exclude any communication with the media about Miss Lively, Mr. Reynolds, or their companies unless those communications fell within a topic that the Wayfair parties in their sole discretion deemed to be sufficiently connected to claims or defenses in the case. But Miss Lively's complaint alleges a secret, untraceable smear campaign. How do you know there's a secret? How do you know? How do you know is what I just don't understand. If it's secret and untraceable, how? Or are you just assuming? And it cannot be left to the alleged perpetrators of that campaign to exercise topic-based discretion. The Lively Reynolds parties have offered to accept a list of reporters, media by topic, but do not agree with the Wayfair party's way to their sole discretion exclude certain reporters. Although, because they believe that certain communications about Mr. Lively, Miss Lively, Mr. Reynolds, the CRD complaint, the actions, or the Lively Reynolds companies are somehow irrelevant, which is not a basis for withholding this information. Second, because Wayfair Party's retaliatory smear campaign is alleged to be ongoing, the Wayfair Party's attempt to cabin the responses to just such a short window ending with Miss Lively's filed her CRD complaint is wholly improper. Finally, the Wayfair Party's attempt to limit their response to those individuals that are reasonably known or ascertainable makes no sense. Surely the Wayfair parties know who they spoke to and when, and those individuals must be identified. 3, the Wayfair parties should identify the content creators they communicated with. With the exception of It Ends With Us, each of the Wayfair parties are asked to identify all content creators with whom you have communicated in any manner concerning Miss Lively, Mr. Reynolds, the CRD complaint, the actions, the Lively Reynolds companies, or the digital campaign from May 1st, 2024 to present. As modified, the Lively Reynolds parties propose defining the term content creators to mean any individual or entity who seeds, generates, creates, or influences social media content or provides related digital or social media services directly or indirectly at the request of or on behalf of any Wayfair party or their agents or affiliate. I will say, like, I don't know everyone. Like, I've been doing branding and marketing in the online space with a public presence for the last 6 years. I'm newer to like the pop culture commentary space, but no one I've known has been getting paid or is on the payroll or anything like that. Not to say there isn't. There's a lot of people out there and a lot of people I don't know. But I'm just saying, like, I have not come across anyone so far that is generating anything, any content that's coming directly because Wayfair told them to or contacted them or because they got information from those parties. Again, not saying it couldn't be happening. Yet the Wayfair parties have repeatedly insisted on arbitrarily limiting the term content creators to only those individuals with at least 10,000 followers or subscribers on any platform and exclude niche individuals. Interesting. I wonder what they mean by niche individuals whose platforms are unrelated to the subject matter of the litigation. Wonder what they're going for there. Now they propose an entirely new term altogether that is limited to individuals that create or disseminate original content and who were engaged by any Wayfair party in connection with messaging, promotion, or reputational management concerning the subject matter of the litigation. Like other proposals, this too places too fine a point and appears designed to intentionally exclude certain individuals from being identified. As parties deeply entrenched in the entertainment and public relations industry, the concept of a content creator should not be this difficult for the Wayfair parties to grasp, and it should not require a motion for the Wayfair parties to produce basic information, which can and should be promptly produced. I also feel like hasn't Blake had issues with turning everything over? I don't know. The thing is even if there is one email, one anything, whether nefarious or not, it will turn into a massive PR battle. And I think ultimately at the end of the day, this is what it is. There's many times lately in terms of the law, I'm like, is Blake still going, like, genuinely, and let me know in the comments. And I struggle to keep up. I feel like the goalposts keep getting moved because is it still about SH? Because the emotional trauma, distress has been dropped. I just feel more than anything, this is a PR battle. And hey, that goes to both sides. And as I said, my biggest struggle of 47.1 is how do you say that one side is allowed to completely destroy someone's life, leveraging marketing and PR, especially when at the end of the day, when you look at the powerhouses of Blake and Ryan, their financial resources available, how is it okay to say that just because allegations were made, that side can completely leverage PR to destroy someone's life and the other person can't respond? Because it's not just that Justin can't have a defamation suit against her. The only one that's allowed to say anything about this is Blake, which was proven in the amicus brief when they said, this guy was trying to shut her down from holding press conferences and shit. And I think that's what her team's leaning into here of like, we can contact content creators. We can go to New York Times. We can do all of this, but you cannot because Blake's the one that made the allegations. And due to that, it is privileged speech, which is what the judge had said. Oh boy. Oh boy. We'll take a quick look at the order the judge made. Again, I'm not a lawyer, so sometimes if there's a filing that I find very interesting, particularly applicable to my field of expertise, which is branding, marketing, and PR, then, I love going through it. There's some filings I love to read front to back. And overall, I'm not building my channel or trying to, building my channel off of just reading lawsuits. And also, I'm not a lawyer at the end of the day. So let's have a look here. This is, and I have to watch the time because I literally have someone coming to pick up chickens. They bought some of our chickens. So I have to watch the time. But this is what was filed just this morning. So again, Blake's team hit the ground running on PR. They went straight to people. It says, okay, consolidated defendants Blake Lively, Ryan, Sloan, Vision PR, Sloan Parties, New York Times, and together Lively, Reynolds, and Sloan Parties each moved to dismiss the amended complaint of Wayfair Studios. Justin, Jamie, It Ends With Us, Melissa, Jennifer, and Steve, pursuant to Federal Rule of Civil Procedure 12B6. Reynolds, Sloan, and Vision PR additionally move for an award of attorney's fees and costs pursuant to New York anti-SLAPP law. So that's, to me, just building on all of those amicus briefs, because amicus briefs say they should be awarded that. Finally, Lively, Sloan, and Reynolds moved to strike Exhibit A to the amended complaint pursuant to Federal Rule of Civil Procedure. For the following reasons, the motions to dismiss are granted. The motion to strike is denied, but the court will disregard Exhibit A to the amended complaint for purposes of this motion. Motion for fees are denied without prejudice to renewal. So I think they can resubmit about that as well, which is interesting. So I guess it's not saying that they won't be paying Blake and Ryan. The Wayfair Party's amended complaint contains allegations regarding a dispute between two well-known actors over the making of a Hollywood motion picture. Virtually every fact is hotly contested. For purposes of this motion, the court accepts as true the well-pleaded allegations of the Wayfair Party's amended complaint. So for purposes of this motion, the court accepts as true the well-pleaded allegations of the Wayfair Party's amended complaint. People Magazine didn't put that in. I'm just not a fan of media manipulation. And that's what the headline of that People article is. Accordingly, the narrative set out below does not reflect the court's own findings, but simply represents the accounts of events stated by Wayfair Parties in their amended complaint. At this stage of the proceedings, the court has not considered whether the allegations in the amended complaint are true. In addition to the allegations in the amended complaint, the court has considered several documents which are deemed to be part of the amended complaint as a matter of law. A complaint is deemed to include any written instrument attached to it as an exhibit, materials incorporated in it by reference, and documents that, although not incorporated by reference, are integral to the complaint. If a complaint makes clear, definite, and substantial reference to a document, for example, by quoting it extensively, the entire document is deemed to be part of the complaint. Relatably, if the complaint relies heavily on the terms and effect of a document, but for some reason does not include the entire document, the court may consider the entire document as part of the complaint. The purpose of this rule is to prevent a complaint from surviving simply because a clever plaintiff included certain parts of a document and left out others. Under the standard, the amended complaint is deemed to include the New York Times article that is subject of the Wayfair Party's defamation claims. The accompanying video, Lively's California Civil Rights Department complaint, a list of 17 protections demanded by Ms. Lively to turn her work, and emails between the New York Times and Wayfair Parties. Each of these documents is extensively quoted and dismissed in the amended complaint. Or discussed, sorry. Each of these documents is extensively quoted and discussed in the amended complaint. The complaint also relies heavily on the terms and effect of each document, either because it alleges the terms are defamatory or because it alleges they constitute a contract. In determining whether the Wayfair Parties have stated a claim for relief, the court does not consider Exhibit A to the Wayfair Parties' amended complaint. Docket number 50-1. Under the federal rules of civil procedure, a defendant is entitled to know the allegations against it and to have those allegations framed in separate paragraphs with sufficient clarity to allow defendant to frame a responsive pleading. The body of the Wayfair party's amended complaint is 224 pages long. Like, I can't even imagine the judge having to go through all of this. Docket number 50. Exhibit A is a timeline providing a summarized account of the sequence of key events, which is an additional 168 pages long. Docket 50-1. It is significantly but not entirely repetitive of the amended complaint, and it does not set out its claims in numbered paragraphs as required by federal rule of civil procedure. The document is not a written instrument, but evidence's legal rights or duties, or otherwise forms a basis for the Wayfair's claims, but is simply an additional narrative summary. If the Wayfair parties wanted any factual statements in the timeline to be considered, they should have alleged them in the amended complaint. So they have the parties here listed. It ends with us, early production of the film, pre-production. Looks like he's just summarizing everything. The initial filming. Return to set, the 17-point list, post-production. It looks like he's just summarizing things. So what we'll look for is the conclusions. All right, on my way to finding conclusions, I found this impermissible pleading. All defendants argue that the amended complaint should be dismissed without further analysis because it engages in impermissible group pleadings and otherwise violates federal rule of civil procedure. Under Rule 8, a complaint is required to give the adverse party fair notice of the claim asserted so as to enable him to answer and prepare for trial. Defendants argue that they lack the proper notice of the claims against them because the amended complaint consistently makes allegations regarding the lively parties and the Wayfair parties, leaving defendants unable to discern which of them purportedly injured which plaintiff and how. I can see how that would be difficult. It's not me being Team Blake or anything. Like, that's, I can see how that would be difficult. I don't know what the remedy to that is or anything. Maybe I should have a lawyer on the channel. Docket number 87-6. This issue is compounded by the fact that the complaint's length and tangents make it difficult to understand exactly how the facts alleged provide a basis for plaintiff's claims. Docket number 106-9. Rule 8 does not demand that a plaintiff be a model of clarity, so long as it provides fair notice of what the plaintiff's claim is and the ground upon which it rests. And it gives case law. Dismissal under Rule 8 is usually reserved for those cases in which the complaint is so confused, ambiguous, vague, or otherwise unintelligible that its true substance, if any, is well disguised. The Wayfair party's amended complaint is lengthy and repetitive, and it relies heavily on group pleadings, but is not so confusing or lacking in substance that dismissal is appropriate. Okay, so the Wayfair party's amended complaint is lengthy and repetitive, but it relies heavily on group pleadings, but not so confusing or lacking in substance that dismissal is appropriate. The key to Rule 8's requirements is whether adequate notice is given. Although the amended complaints lack clarity as to the boundaries of certain claims, defendants have adequate notice of many core claims that are evident from the face of the complaint, and they are being fully briefed by the parties. For example, it is evident from the language of the complaint that the civil extortion claim is based on Lively refusing to promote the film unless she was allowed to create her own cut. Lively demanding with extortionate threats that Baldoni and Heath support her PGA certificate, and Lively and Reynolds attempt to force Baldoni and Wayfair to read a statement apologizing for issue of the film. That is still wild. I just can't even imagine. It's like, do you know who we are? That's the vibe. It is evident that the defamation claim is based on Lively, Sloan, and Reynolds providing the CRD complaint to the Times before it was released and stating to the Times in substance that the Wayfair parties engaged in inappropriate conduct towards Lively and retaliate against her for reporting the misconduct by engaging in a campaign to ruin her reputation. Sloan and Reynolds making additional statements that Baldoni had committed misconduct, SASH, and the Times stating that Baldoni, Heath, Nathan had engaged in a smear campaign to ruin her reputation. Plaintiff's submission is a model of neither clarity nor brevity, but it is sufficient to put the defendants on fair notice of these claims. Where the amended complaint does lack clarity, the court will consider only the claims of which defendants have fair notice. To the extent a fair reading of the amended complaint does not provide notice that the wayfair parties are making a particular claim against a particular defendant based on a particular statement, the court will not parse through the various allegations and documents to determine whether a claim could theoretically be stated. For example, although the amended complaint alleges a CRD complaint was rife with lies and doctored evidence, docket number 50, the court will not consider whether the CRD complaint contained any defamatory statements beyond those specifically alleged in the amended complaint. Similarly, in analyzing the defamation claim against the New York Times, the court will not consider whether any statements in the article are defamatory beyond those identified in the amended complaint. The wayfair parties have an obligation to identify the statements which harm them, rather than gesturing at a document or a category of statements and forcing the defendant to guess at which ones are actionable. Likewise, if the complaint uses the lively parties or wayfair parties in a context where a particular plaintiff or defendant is not clearly indicated, the court will not guess at what claim the amended complaint is attempting to make. Such a course would promote litigation by ambush, allowing plaintiffs to use vague pleadings to hide their claims only to spring them on defendants in opposition briefing or at trial. I mean, that does make sense. That does make sense. That seems fair. I mean, if you're being tried to court for something, whether you're, Blake Lively or Justin or anyone else, I feel like you shouldn't be ambushed at trial. I do agree with that. Accordingly, though, the court will not strike or dismiss any allegations on Rule 8 grounds. The court will consider only those claims that a reasonable defendant would understand to be asserted against it based on the allegations in the amended complaint. So it goes on to civil extortion as well. It talks about the wayfair party's first claim is for civil extortion under California law against Lively, Reynolds, and Sloan. In support of this claim, the wayfair parties allege, one, that Lively refused to return it to production unless the wayfair parties agreed to return to production demands, that Lively threatened to abandon her contractual obligation to promote the film or approve marketing materials unless the wayfair parties agreed to co-fund a screening of her version of the film and eventually release that version, and grant her a producer credit and support in seeking the PGA designation. That Lively threatened to boycott the premiere unless Baldoni was excluded, aka put in debasement. That Lively and Reynolds threatened to attack Wayfair in the press if it did not take the blame for problems during filming. That Sloan carried out Lively and Reynolds' threats by spreading false allegations that the Wayfair parties had engaged in or concealed misconduct. Lively, Sloan, and Reynolds argue that none of the alleged acts are wrongful and that they did not obtain money or property from the Wayfair parties. Wayfair parties argue that they are not required to allege a transfer of money or property and that the threats alleged in the amended complaint are sufficient. Docket number 160, Lively, Sloan, and Reynolds have the better of the argument. Interesting. So they go over governing law. The parties advance different understandings of the tort of civil extortion under California law. Lively, Reynolds, and Sloan argue that civil extortion is a cause of action for monies obtained by duress, which is separate from the crime of extortion and requires proof of actual damages. The Wayfair parties argue that civil extortion is a cause of action based on the criminal extortion statute and that does not require money or property actually be obtained. Sorry, guys. I'm trying to fit in as much as I can. I've got people showing up to the farm shortly. I'm like, you're probably thinking, Ashley, take a breath. Yeah, I want to, but I want to get in as much as I can for you guys before I have to run. Lively, Reynolds, and Sloan are correct. Although the claim is labeled civil extortion, it is derived from the common law rather than the criminal extortion statute and requires actual damages. All right. The crime of extortion involves the obtaining of property or other consideration from another with his or her consent induced by wrongful use of force or fear. California permits plaintiffs to bring a claim labeled civil extortion. However, an action for extortion under California law is more appropriately considered a claim for monies obtained by duress. All right, so they just go on about the law and case studies. Let's see what else they have here. All right, let's hop over to the conclusion. The motions to dismiss are granted. The Wayfair parties have leave to file a second amended complaint by June 23rd, 2025, amending only the allegations relevant to the claims of tortious interference with contract and breach of implied covenant. The motions to strike are denied. The motion for fees and damages pursuant to New York Civil Rights Law 70A and California Civil Code 47.1 are denied without prejudice to renewal by formal motion. So that's what happened. And Blake is now making it a PR move, which she's basically arguing that it is completely within her rights. Wait till you see what's happening on Google. Wait till you see what's happening on Google. I'm going to have to pause for a second because the dogs are freaking out, and then I can show you what's happening on Google. I'm sorry if there's noise in the background. The dogs are acting like nuts. But how long have I been recording this? About 45 minutes. And within the 45 minutes, it was 9 minutes from the time I started recording that people had hit the ground running with this. Now look at what's happening to SEO. So search engine optimization, what's happening to Google. Justin Baldoni's $400 million countersuit against Blake Lively, Ryan Reynolds is dismissed. Justin Baldoni's $400 million lawsuit dismissed. Dismissed. Defamation suit dismissed. Judge tosses Justin Baldoni's $400 million lawsuit against Blake Lively. Judge throws out Variety. Justin Baldoni's $400 million defamation suit against Blake Lively. Justin Baldoni, TMZ, loses legal war with Blake Lively. Lawsuits dismissed. US Weekly, judge dismisses Justin Baldoni's $400 million lawsuit. This is going to dominate the headlines. And I imagine if I pull up Justin's Google page, it's the same. I'll show you quickly. So this is Justin's page under Justin Baldoni news. It's the same thing. Blake's big win. Justin Baldoni's $400 million countersuit tossed out. The dogs are acting like nuts. I apologize, guys. Justin Baldoni's $400 million countersuit against Blake Lively and Ryan Reynolds is dropped, dismissed. Defamation suit against Blake Lively dropped. One of the top searches, if you scroll down, is people running with it an hour ago. Again, you tend to see the exclusives from Blake Lively's team over on People. They likely got the news from Blake Lively's team, and then it was disseminated out to the other platforms. Daily Mail, TMZ loses legal war. So there's that. It's obviously a curated narrative. It's not that he lost the legal war and he can amend it and refile it, but that's PR for you. And that is media manipulation. It's narrative control. Blake Lively has been working hard to control that narrative. And on top of that, she's had all those like very family-friendly videos over on Instagram. It was shut down like that when the TikToker had the video about her being entitled and rude. That was all shut down because you can't have anything like that disrupting this. And if you watched my live from earlier, you would have noticed that her being entitled was dominating Google. I don't see it anywhere now. How many pages do you have to go before you see something like that? Yeah. So this is dominating the news cycle, as it probably will for a bit. And I imagine her team's going to issue like an official statement or something. But anyway, that's the newest update in the Blake Lively, Justin Baldoni PR wars and lawsuits. It'll be interesting to see where it goes from here. I think at the end of the day, sorry, I'm like thinking in my head, I have a lot of questions about that law and how people can't defend themselves. While I agree, yes, victims need to be protected and feel safe speaking out, I do have concerns about how, especially big parties like this, can leverage their very expensive and experienced PR teams to destroy, and connections to destroy someone's life with the potentiality of there being a false allegation. I don't know, maybe there's a middle ground where, no one can do press conferences or go to the New York Times until it's sorted out. I don't know. But I feel very uncomfortable with this law. I feel very uncomfortable that Blake and Ryan, or individuals with that kind of power, can leverage the law, even if there is a true nature to, or an assumption that it's without malice and they believe it's to be true. The damage is done in someone's life by the time you go through trial. So I imagine we are going to see a lot of flooding from Blake Lively. I'm probably predicting some happy, positive family stories over the next couple of days, but there you are, guys. I have nothing else to say about that. Still processing it because I pulled this up in real time. But let me know what you think in the comments. And with that, guys, I'll see you in the next one. Bye, guys.